Hello everyone, a very good afternoon. This is Priyal Bhatia, the Chief Community Officer for DPO Club, and it is my pleasure to welcome you all today for our webinar on digital fingerprint, securing authenticity for AI generated content. This topic is something which is buzzing in the industry right now because we know that generative AI is continuing to shape our digital ecosystem. But with that, it is becoming very difficult to differentiate between human generated as well as AI generated content. So, to understand more on this, we have an expert panel with us today. We have the moderator as Colonel Binoj Koshy, who is a chairman to DPO Club. Welcome, Binoj, sir. We have Rohan Sahu, who is founder at ContentLens. We have Dhruv Suri, partner at PSA. And we have Utkarsh Sharma, who is leading digital media implementation at Blender.io. So over to you, Binod sir. I think you're the best way to start. That how exactly do we understand this? How is it that organizations navigate through this challenge in the industry?
Thank you very much, Priyal. And it is a pleasure to come back again on a webinar of such vital topics as we do at DPO Club. We've been addressing a lot of aspects of AI, especially after the new regulations were in and the concern of the government of India. Per se, if one were to ask, by virtue of being in the government also, government of India would never like to touch the aspect of exploiting and usage of AI. Yet, what it demands is being self governed, responsible, and for that matter, from a more standpoint with regard to usage of AI for its good rather than for negative aspect. But as we are aware, an Indian law also doesn't actually propose a penal form of a law like in many other countries. So, what has happened over the period of time is the laxity to adopt AI and to use it for ethical means has also been a concern. And there are large number of crimes which probably, as we discuss, we will come across. I have an esteemed set of panelists from different walks of the AI regime. I'll request a small introduction from each one of you, please. You can start with Dhruv and then probably go to Utkarsh, and then probably to Rohan, and then I'll bring up the questions for that.
Thank you so much, Colonel Koshy. So, very quickly, my name is Dhruv Suri. I'm a partner at a law firm headquartered in Delhi called PSA, and working very extensively in the TMT space, and especially, you know, working on the very topic that we are here to discuss and talk about.
Yeah, I'll go next then, sir. So, hello everyone. I am Utkarsh. I am leading digital media implementation for provenance in Flinders. So, we work with various media companies and in specifically in music space, as well as we are focusing on in film industry also. One of our major focus area is copyright with respect to AI generated content, as well as now we are looking into, as this new mandate has come, as sir has mentioned. So we'll be looking into how it can impact the news industry also, because information is a key aspect. So happy to be here and looking forward to contributing.
Thank you, Utkarsh. So, hello everyone, this is Rohan here, founder of ContentLens.ai. So, we are in the domain of IP protection, be it in the form of, it could be music, it could be movies, it could be one's likeness, right? So, we cover the entire gamut, and currently we are working with some of the leading record labels in the world. And also, we've recently just started working with a few celebrities as well on likeness protection. So that's a brief about me. Wonderful to be on this panel with all of you. Over to you, Koshy.
So, I think you're on mute. Okay,
Sorry. Yeah. Thank you very much, Rohan, for that introduction, especially by virtue of your domain name also has got .ai. So we presume that you would be day in and day out breathing AI in all forms in that manner. Yeah, there is a lot of concern in India with regard to the use of AI for ethical aspects, probably, especially while generating content. So, Rohan, by virtue, just to get set the context right, can you explain and throw some light on watermarking with respect to AI generated contents, please?
Right. So watermarking is a technique that has been used for a while now. Basically, to indicate, it could indicate who owns that content, or it could indicate what technology was used to create that content. Right. Historically, it's been used for that. Right. And in the past, it's also been used to transmit some information within the particular piece of content. But now what we see is that because content AI generated content has become so hyper realistic, right, that you cannot differentiate, which become very difficult to differentiate between original or human generated content and AI generated content. So the question is, what is real in today's world when it's so difficult to differentiate? How do you identify what is real and what is not? Who has created it, etc.? And that's where watermarking comes in. And there are multiple forms of watermarks also, but essentially it's a way to indicate either the source or the type of content, or ownership or something like that. Koshy, you're on mute, I think.
Yeah, sir. My next follow-up question, Rohan, is again to educate the audience who are listening to us right now. What is the difference between a visible watermark, like a logo in a corner, which you see generally, and an invisible watermark hidden in a file? We have heard of steganography as a concept, but then in terms of AI generated content, which is the more actually more effective, or at the as part of a screenshot or an editing, what would become more live in this case?
Right. So you mentioned steganography. So there's visible watermarks which you can see. Steganography also has been around for a while, where you put in a message within the content. Right. Now that was used in the past. And in today's world, what we use is invisible watermark. So it's not really, you're not putting in a message in the content, but you're basically altering the content slightly. So it could be if you're looking at an image of a man on a beach, right? There's some blue color, there's some green color, and essentially you're just minutely altering the pixels in a way that it's not perceptible, right? But using AI, I can decode it. So I am adding some pixels, and I'm able to recover that pixel because I'm adding it using some logic, right? And that when I decode it, I'm able to link it to a certain record or a certain file, which indicates who owns it, how it was created, the entire provenance of that particular image, right? And the same works for music also, audio also, where you add certain amount of noise, right, which is imperceptible, right? And so and again, it applies to video as well, movies and other things. So that is how the invisible watermark side of things basically work. Now, in terms of which is more effective, right? So, see, visible watermarks can be deceptive also. Today, you put the Gemini logo in any image, by default, people will say it's AI generated using Gemini. If you see at the bottom right, Gemini images have an icon, right?
True.
Now, that's also become a way for people to just pass off things as AI generated, which is not correct, right? So visible watermarks pre this AI world, had a certain purpose. Like Getty Images and others would use it again to mask and to show, to basically protect themselves from screenshots and other things. But now it's become so easy to remove visible watermarks, right? It's basically, you're indicating that, hey, I'm protecting myself by adding this IP, by this logo in this particular position. So you're giving away, the location or the place where somebody needs to edit. In an invisible watermark, you don't give anything away. Like, nobody knows, right? If you ask me, in this particular image, where is the information, I cannot tell you, right? It's an AI model which is going to decode and tell you with certainty, that what sort of masking has been done on top of it. So invisible watermarks are a lot more robust, right? And they are also more, I would say, appealing to the eye, because if you look at images like Getty and others, not take any example, right? You have to actually put the logo right in front of the image. Now that is blocking, it's blocking the entire image. Similarly, if one has
True.
to label AI generated content, and if every piece of content has AI generated, AI generated, AI generated, right? It's an eyesore. So that's one of the reasons why we also recommend going for invisible watermarks, right? And possibly some small icon, like what Google uses or like what Meta uses, or it could also be the content credentials icon, a small CR icon. Where that's a better approach than adding the entire sort of name of the company or the source, in terms of how it was created. So invisible, and the other question around screenshots and editing, right? So visible watermarks can be stripped away. I can take a screenshot, I can crop it, cut out the visible watermark part, and to a third party, they won't even know that there was a visible watermark there. But an invisible watermark remains even after that sort of editing, right? And so that is why it is a lot more powerful technology than a visible watermark.
And then probably you can't identify where it has been embedded to. I think that is also
Correct. Correct, correct. So, I mean, now watermarking has become a lot more advanced. Like we've got watermarks where you can prompt an watermark. So I can actually say, prompt a specific thing in this particular image, right? If you care about watches, if you care about shoes, if you're Nike, you would want to watermark shoes. If you're Tag Oil, you want to watermark watches, right? So you can watermark specific objects, and whenever somebody extracts that object also from an image, you can actually detect that, hey, this was taken from this particular image, right? So that's how powerful invisible watermarks are. Yeah, and so there's a trade-off in terms of one has to ensure that it is imperceptible, right? And that's where most of our R&D also goes, in ensuring that. So we have published numbers for that. We have third-party bodies, industry bodies who have reviewed, in terms of imperceptibility, right? So that's a key to invisible watermarks, ensuring that the audience doesn't see or hear. They can't make out between the original and the watermark. Only then would it work.
yeah. Rohan, now that you've given us a quite a technical perspective, I'm tempted to
Right.
ask a very technology question, and I'm
Okay.
sure that this will clearly clarify a lot on the audience. They say that while embedding algorithms for AI watermarking, you generally play on the white space in an image. Is that true?
That's not entirely. I like I mentioned, it is that was earlier, that was the case,
Okay.
right? Now the models have become a lot more advanced. And for example, if I have to protect this watch, right? Now there's no white space. I have to watermark this particular watch, right?
Hmm.
Literally. So you can prompt and say watermark the watch, and I have to go find that watch, watermark it, right? You can also not say anything. You can just be quiet, and then you just say, okay, go and do your best watermarking. Then we figure out what are the best objects, what are the top objects that are present in this image, and we watermark it. So the white space watermarking is, I think that was probably the norm earlier. Now
Yes.
it is more about importance, right? What should I watermark for max ROI? If I watermark a white space, somebody extracts from the white space, it's not going to be any value to anyone, right? So yeah,
Yeah.
earlier, if
Thank
you
you.
remember, also it used to be in like bottom right, top left, all
Correct.
those corners, right? But those are the easiest ones to strip off and to
Mm,
modify.
yeah. No, I really like the answer because from an hacker perspective also, generally during old days, we are from the old school of the IT guys. So we generally look for the white space to embed or to masquerade some viral code and things like that. Yeah. Thank you very
Yeah.
much, Rohan sir. I come back. Sorry, Dhruv sir. I come to you. You're from the corridors of power. Actually, you sit at the corridors of power, and being from the legal fraternity, so we look a lot onto it. Frankly speaking, I would like to counter you and tell you that in the mighty there is a thought that we don't want to have an AI act or an AI regulation, as in the case of the European Union, which actually came out with it. So from that standpoint, we've got the IT Act, and those IT Act rules and regulations is the only essence that can actually bring out certain stipulations into use of AI. And so my direct question to you is, with regard to this new regulations that have been, the rules that have been added very recently, a month back, it does tighten the noose around AI generated content. In fact, I myself got introduced to this word called SGI, or set of words called SGI, that is synthetically generated information, and they formalized the definition of that in this particular regulation. The new IT Act has a clear message for AI creators. It says label it or you lose it. Watermarking is no longer a feature. It is a legal necessity to probably ensure the proprietary nature of the content, or to safeguard the interest of the person who has generated that content. How do you think that the implementation of this watermark can be ensured? Probably if somebody wants to crop it or open the source code and edit it. So what is that safeguard that is existing in the law?
O- Okay, first, thank you, Colonel Koshy. Great question. I would say I think Rohan has given an excellent perspective in terms of how watermarking is done in today's day and age. I would, in fact, in the course of this session, also urge him, to give some insight about C2PA as well, and what the larger intent of C2PA is, and the problem it's trying to solve. But coming back to your question, one, I want to say that I think it's a great initiative for the government to come up with a regulation that specifically deals with SGIs, right? So I think for starters, I think that's a great thing. Do we need a law like the EU AI Act in India? I don't think we do. At this point of time, I think our present laws are by and large sufficient to allow for some level of checks and balances, yet encourage deployment and R&D in the space. Today, even if you look at technologies like the ones that Rohan is working with, you want technologies like this to be out there, right? You want the ability to be able to identify synthetically generated information on the internet with easy to access technologies, as opposed to getting embroiled in regulatory frameworks as a AI company, going through tedious amounts of due diligence before a vendor onboards you, because there is legal liability, right? So think of like this. I think Rohan mentioned that he's working with some music label, right? If today in India you had a very, very rigorous law like the one that you had in, or like the one you have in EU, Rohan's onboarding, right, for such a critical tool would end up being like a 8 to 10 month long process with the kind of diligence and checks that they would do. And they would put all kinds of liability indemnities back on Rohan, right? Like if something goes wrong, if the authority imposes any penalty or son on us because of your tool, Rohan, you will be held liable. And look at the amount of innovation we will end up completely compressing in the process if we actually have a stringent law like that. And I think India, given we have excellent engineers, we are building fantastic tools. And a lot of what we are building, or at least, I mean, some of it is built on top of existing AI foundational models, but a lot of it is also not built on it, right? In this space, especially in terms of detecting deepfakes. So I do think that that level of innovation will only be facilitated if we don't have a very, very strict regulatory framework. That said, should activities like this be regulated? Should there be a law in place from the perspective of the company? Absolutely. And today, according to me, the regulations that we have are by and large sufficient. They're a great starting point, because what they require is they require platforms, intermediaries to adopt technologies to be able to identify any kind of synthetically generated information going on their platforms. And I think that in itself, right, while the government has not prescribed standards in terms of what kind of technology you need to adopt, it's given them some kind of it's given them the principle, and it's allowed them and given them the flexibility to figure out what they want to adopt. I'm still on the fence in terms of should there be strict criterias in terms of what you should adopt? What should there be strict parameters in terms of technology so that the liability exposure for intermediaries to some extent can be minimized, where they can go in and say, look, you came up with a standard, I've prescribed to it. So therefore, now if something goes wrong, it cannot be my liability. I'm on the fence for that. But I think even the way the law is presently worded, right? The onus is not so much on the technology to work. The onus is to make sure that you have taken the right steps to be able to identify it. And I think that distinction is very important, right? It's not as if every single time the intermediary is required to identify it, and if they don't, there'll be liability exposure. Because there is no way every single time even a tool like Rohan's will be able to identify something in the market just by the nature of how technology works. But as long as the lowest common denominator in terms of what is available in the market to be able to identify this content is adopted by these companies, okay, I think they meet a minimum benchmark. And we will see how the AI, how the SGI world evolves. The law will also catch up and evolve. But I think for now, as a starting point, this is an excellent initiative and an excellent law. Of course, in terms of the timelines given to take down content, etc., those are fairly stringent. So what I'm hoping it doesn't translate into is this, that companies adopt technology because technologies also help them identify SGIs faster, and because there are shorter timelines to take it down, they purely rely upon technologies and don't sort of apply, a better filter and keep taking down content as opposed to pragmatically evaluating whether it should be taken down or not. Because if you have to take down something within 3 hours, you don't really have that kind of time to then be able to exercise discretion, right? So if a third party tool comes and says, okay, this is not okay, this has SGI, chances are you will just take it down without actually verifying whether it truly contains SGI or not. So I'm hoping it doesn't get to that, but by and large, I think it's an excellent law. And um, uh, in the I would say space where we are in terms of AI development and in terms of where the technology stands, I think India, because of the current regulatory framework not being too curtailing on businesses, can really be in the forefront for building tools to be able to identify deep fakes and content that has misinformation leading.
Yeah. Just a follow-up question. The way you put it across, it looks as if that there's large amount of regulation important, which is important in this whole ecosystem. Now we have a telecom regulator, we have an insurance regulator. In for that fact, even privacy as a law, we have a regulator. The law presently doesn't talk of a regulator unless there is some talk within the mighty to come out with some Ministry of IT. Do you think that we really require a regulator uh, exclusively for AI management in India?
I actually don't think so. I think eventually a lot of the AI implementation enforcement should, in my view, and we'll see how that plays out, should go before the Data Protection Board, because issues around privacy are so intertwined with adoption of AI and in terms of how AI also processes data, that I think it will be a little unfair to have two regulators who, on the merits of the matter, may give two different findings purely on the basis of their understanding, and then create some sort of like conflicting opinions that exist in the market. So I do think anything that has an overlap with aspects of privacy, and AI tools most certainly do, there should be one common regulator.
Oh, wow, wonderfully answered. I hope the Secretary Mighty is listening to what you have said, because it's very important from that aspect. Um, and I hope we see a better regime on this front as India goes by in its journey. Utkarsh, coming to you, I know by looking at you, I can make out there's a lot of AI floating around, and your fingers are also probably tempted by AI every minute. So and you being a labeler, I thought I'll ask an apt question for
Mhm.
you, which is quite relevant to what the topic is today. The 2026 synthetic content regulations, it does talk about distinguishing from real and AI generated. So, as a labeler, how do you determine the threshold for realism when dealing with hyper realistic artistic filters or AI enhanced restorations? Generally, we do AI enhanced restorations also. At what precise point does a creative enhancement trigger the legal requirement for a prominent and permanent disclosure tag?
Yes, Colonel Koshy. Actually, I would.
I've actually asked a very legal sort of a
So no,
question.
it's very
But
interesting and very needed to be answered. So I would go into, like, I will delve into the aspect of SGI more in more detail. So SGI, when we talk about, it's synthetically generated information, which means it tries to impersonify either a person or a real life event which has been happened or is happening, a live event. So in that context, it can be two things that we can possibly classify this into. That can be a permitted use or permitted SGI, and second can be a prohibited SGI. Permitted is something which means it's not harmful. It's it also exempts satire and certain other categories. And if an artist uses it for creative purposes, creative expression, for entertainment purposes, for example, so in all those cases, it's something that can be labeled by the creator itself, and it can be put onto some kind of a platform. And there can be or cannot be the takedown request. So that's not stringent, something that can be enforced into a permitted usage like category. And when we come to prohibited use, it's everything. It's deep fake, it's wrongful use of anyone's identity or privacy. So as we have seen, all the unlawful activities that happens. So all that, there is certain stringent rules, as Dhruv also mentioned, that the government has been talking about putting in. So if we talk about these two categories, now we can see how, like, if a labeler has to label it with respect to how much it impersonifies a content or a person. So then I think the question should be looking into all these aspects, and then going deep into why that person is labeling, what is the content, and going into the details of the provenance also. Because now the second part of the equation is, generally when you update a synthetically generated information or any AI content, it's not, many times it happens that it's not just one iteration. It is a part of a multiple iteration. Let's say you start with some edit at some place, and you will put it into back into some other AI tool, it's possible, and you will transform it more, and then you can put it into some other AI tool, then you can transform it much more. So in that case, again the question comes to, at first level it's not that real, second level it becomes more realistic, and third level it's like actually impersonifying any person's privacy or identity. So these all, looking into all these things, the question, if I have to answer it, it's not straightforward labeling, but we have to look into the tiered category also, how you can create like certain tiers in which the content is being labeled. And if you have to check into the realistic part, then there can be questions of consent also coming in, like, let's say that actually permits the usage of that particular creation of SGI. So in terms of legal requirement, I'm not sure. I think Dhruv can answer. But in terms of the technical labeling aspect, so there are multiple aspects that needed to be explored. And a provenance tag, as Dhruv has mentioned and Rohan has mentioned, C2PA generally has a provenance journey information. So which tells you how and where this particular content has come from, and based on that, the decision the labeler can take. And using these classifications, I'm just giving certain ideas, they can put a label or a realistic tag on it. But all these things needs to be considered and by the labeler actually,
Go.
I would
Yeah,
say.
Rohan, just a follow-up question from what Utkarsh had said. In conventional watermarking, we have delible and indelible. So, in your AI-generated content watermarking, Is there these two concepts, indelible and delible? Rohan?
Hello.
Yeah. Did you get my question?
Yes.
Sorry, Rohan, am I audible?
No, I couldn't hear you.
Yeah.
I think I had a brief. Yeah.
Okay. In the
I
case
can
of
hear you now.
conventional watermarking, we have what is known as delible and indelible. Does that similar concept there in digital watermarking in your in watermarking of digital contents? There's something called indelible
Yeah.
and
So, uh, can you hear me fine?
yeah, yes.
Yeah. Yeah. So the same applies here as well. See, in the sense that watermarks can be removed, even digital. I mean, it depends what type of watermarks you're using. Is it proprietary? Is it open source? If you're using open source watermarks, sometimes the decoders are available, you can remove it, right? But if you're using proprietary watermarks like the ones that we use, right, you won't be able to, you wouldn't know what we are using, right? It's basically, we are all playing a game of chess in some ways, right? We're all second guessing each other. What is there? How am I putting it? Right? Am I putting one watermark, two watermarks, three watermarks? Which part is watermarked, right? So it's a game around that, right? So if it is super transparent, if I have to tell you every time that I'm putting two watermarks and they're in this place, then it'll defeat the purpose, right? So watermark removal is people have tried, they've tried things like adding noise, they've tried multiple alterations to the content, image or video or audio, to try to defeat the watermark, right? Now the main thing is, see, if you try very hard, you can. There's literally no technology in this world that cannot be defeated, right? But here the main thing is, can the user perceive it? Like if you add so much noise to the content to defeat the watermark, then it will not be original content, right? You will be able to make out that this particular image, video, audio has been tampered just by looking at it or listening to it, right? So to do well without affecting perceptibility is extremely difficult, because see, you have the original, we have added some noise, now you are trying to add more noise, right? And so that threshold is already, in some ways, it would be beaten by the time one tries to do it. Having said that, there is we are also working with ethical hackers, right? And we are continuously improving our product, trying to understand, what's the boundary, right? But our key threshold or key trade-off is perceptibility, right? One should be able to maintain imperceptibility of that watermark.
Yeah. Thank you, Rohan. Now, Dhruv sir, this is a question again with respect to this indelibility and delibility, removability and all. So, the 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 present regulation does talk about metadata per se to maintain the integrity of that watermark which is put on digital content. Now, what is there in the law for management of these type of watermarks which are indelible yet manipulated by people?
Great question, and has a very practical implication. So first, let me start by saying that the law doesn't use the word indelible, doesn't suggest it has to be indelible. What the law actually says, and it's very interesting because the expression used in the draft rules went through a little bit of an iteration when the final rules came. The draft rule said that intermediaries have to, quote unquote, endeavor to deploy technology based measures, including automated tools or other mechanisms, right? So this is more like a, hey, like adopt best efforts and do this. Now the actual final rules say they have removed the word endeavor, so now it says deploy appropriate technical measures, including automated tools or rather suitable or other suitable mechanisms, right? And the big change now in this is that, look, now it's not a best efforts thing. You have to deploy something. If today you're a platform, there is absolutely no way you can go around doing your business if you have not deployed you can build your own tool, but you have to deploy something to be able to identify SGIs on your platform. Okay. Now the question is that, can if the tool is unable to identify something, okay, or if the watermarking that has been put, or for example, let's just focus on SGI for a second. If the tool is not able to identify or detect SGI, is there a liability exposure for the platform? And the short answer is no, as long as it has deployed appropriate tools, which are, which essentially are what the law provides for. What those tools need to be, what criteria they need to fulfill, whether there is any minimum sort of technical requirement that these tools need to meet, the law doesn't prescribe for that, right? And this sort of goes back to the earlier point that I was making, that should there be some minimum benchmarks and thresholds and technical criteria for these tools? I'm a bit on the fence. It's debatable. We can evaluate that. But the truth of the matter is that if there is a minimum benchmark that's created, it has to be like a low hanging fruit, right? It can't be that like you have to on board like very expensive tools with the most sophisticated technology, and that's the bare minimum you need to do. And as long as tools today are deploying available resources from the market, or whether building it themselves, which allow them to fulfill the requirement of the law, that's good enough. Whether it always works in the manner that it's supposed to, that's not what the law requires it to do.
Okay. Yeah. Utkarsh, I come to a very critical question here in terms of management of AI content. The aspect of takedown. In fact, though the mention is of 3 hours takedown after a content has been found deepfake or objectionable, in fact, the rule is more stringent in terms of sensitive contents when it comes to women and children. They have reduced the timeline to 2 hours. Now, how possible is this, or how impractical it is, or how practical it is? Can you throw some light on this? As a developer or as a hoster of these contents, how easy or difficult it is to abide by this timeline?
Yeah, it's very difficult actually. As a developer, I can say, or wants to label, so it's very difficult. 2 hours or even 3 hours to come to a conclusion, a final conclusion, because like a takedown is not just a temporary relief or something. It's just a conclusion you are giving to this particular content. So you should be able. So the critical aspect, if one has to follow this particular timeline, is to have two things. First is sourcing, like you have to label the content from source or watermark the content from source, that is from the AI tool itself. If it's coming, and the second most important thing is you have to carry a provenance journey, like where this particular content has moved from, which particular tools it has followed, and then there needs to be a human claim also. As if we talk about C2P, the standards, so they talk about two particular very important concepts. One is a machine generated claim, or they call it as a created assertion, and second is a human generated claim, which is a generated or gathered assertion. So a human generated claim is something that a person adds on top of it, a metadata that any detector, like any someone who is detecting it on behalf of someone, or any forensic team, let's say they are in the chain and they have given some kind of verdict to it. So they add a human claim on top of it, that we find this particular content as not following the particular guidelines, or it's prohibited or whatever. So that is one aspect of the provenance journey. So within that particular journey, lifetime journey of that particular content, if you get this particular human generated claim, which can be designated to certain authoritative bodies, for example government institutions, if they say, or certain authoritative bodies you can put in place, or as Dhruv has mentioned, that there can be regulator, the privacy regulator. If certain bodies say, okay, this is not okay, human generated, then you remove it. Generally, the machine which generates a claim, you can track the tool usages, where whichever tool has been used, and uh, how it has been upgraded in the context. So all this journey, provenance journey capture is very important. Source level labeling is very important, and then a structure that needs to be set up within the government and tracking of this structure. So I don't know what body will be handling it, but it's very crucial that
Okay.
someone manages the system. Otherwise, just what like simple techniques will make it loose. Make the keep the system. We have to
Correct.
tighten the bolts.
Otherwise, Utkarsh, as you said, in India, no, we have one of the best practices in terms of digital signature custodian and the guy who gives the digital signature. There's a beautiful
Mhm.
control in India. So, in your context, uh, I agree to the fact that we need a person who will take responsibility of this. But then
Mhm.
uh, probably we may have to learn this as the act gets implemented, as the law gets implemented in its flow. But yes, there is a concern here that we don't like. In the case of digital signature, there is a CA or a certifying agency, and he or she issues the signature, and the signature is verifiable, authenticatable, and all those aspects are there. Yeah, thank you very much for that context. Dhruv sir, I go back again. I'm also a forensic professional, and we used to rely on Section 65B a lot. That is the Indian Evidence Acts or erstwhile. I'm authorized to sign such papers too as part of being from the digital forensics ecosystem. But then now, when it comes to a watermark authentication, of course, I think now it is the Bharatiya Saksharata Adhiniyam, which is I think section 63, if I'm right, comes into play now in place of the 65B, which we used to do. Now, in let's say I'm doing an authenticated watermarking, who is now going to verify that 63 certificate in this particular scenario?
Um,
I know it's a very technical question, but all this will come through as litigations
yeah.
happen in court.
So I think we need to think of it in a real example, right? Let's assume there is a post put up on social media, right? That post is generated through AI. It's synthetically generated content. It results in some litigation, and now the social media company has to, or whoever is relying upon that post, right? Typically 65B is filed by the person who is uh, effectively stating that, look, this is a accurate digital record of from my computer, my laptop, printed by me as it was available. Okay, so
And I think there's a competent authority also. Court does not accept anybody
no,
signing
so
that.
ultimately you will see a lot of times, for example, the client, even in terms of emails, for example, right? Emails require a 65B because they've actually been printed from a digital device, right? So typically the person whose email it is will print it, but sometimes it's not just the person whose email it is, right? They could send it to me, for example, as a lawyer, saying, hey, Dhruv, here's a full thread of the emails that you have. Now, if I have printed it from my system, okay, then technically speaking, most people don't do it, but technically speaking, I am the one who has to give the 65B because I have printed it in the manner that it came to me, my laptop, etc. But typically, what will happen is that clients will print it, and the details of the client's laptops and the client's printer, etc., will form a part of the 65B affidavit that is filed in court to then be able to say that this piece of digital evidence, whether it's an image from the internet, whether it's an email, whether it's a website printout or anything else that we are filing in court, can be taken in evidence because it is accompanied by a 65B. I think in the present situation, the entity relying upon whatever that document is, right? So say if there is an image that I have a problem with in a suit, I need to now print it from a social media website which is synthetically generated, and I need to now present it in court. Because I have taken it down, the 65B will be mine, right? I will say I have taken it out as it was available on the website from my laptop, from my digital whatever, my hardware. Now, in the course of the trial, now the social media company is well within their rights to say that, look, if it's a synthetically generated image, then how it was synthetically generated also becomes a question of trial. And how did that AI company that was in the middle, that is not in the forefront, like today, if a social media company uses a AI company at its as a vendor that is evaluating these images at the back end, I will never know who this entity is, right? Like I will never, as a user, I will never end up engaging with this entity that has been hired by or engaged by a social media entity. But as if the matter goes to court, I will file my 65B, or the social media entity will file the 65B, but say that this was synthetically generated and this was the vendor that we had used. And now in the course of the trial, you may then be able to summon the vendor and understand how that data was, or image or audio or video was synthetically generated. You may have to ask questions around the nature of the algorithm that was used, whether that was used on the basis of some existing large language models. Do they know what happened? And this is complex litigation, right? And this is where like forensic guys like yourself, sir, will also come in to the picture to be able to dissect how this image was actually generated and then furnish a report in court defending or opposing the manner in which this SGI was generated. And then you yourself as a forensic auditor will be subject to cross-examination, because your report will not be taken on face value, it will also be subject to rebuttal. So it will just make litigation more complex where it involves digital content that has been generated or has some elements of SGI.
I'll add a little complexity. Rohan, I request you to come on board. Let's say I generated an image and I went and hired Rohan's services to embed a watermark in it. Dhruv sir, I've embedded a watermark. Now, let us say that image becomes a part of the dispute and a litigation is in play. I need to add that 63 certificate now to prove that my image is authentic, and I had put a commercial watermark in that. Now, when you take a printout of that image, this watermark is not going to appear. Rohan, am I right?
Actually, we've tested it appears in many cases.
No. I think we are talking about two different things. So what Rohan sir is saying is that if you take a printout and then check whether that image using a tool, whether that image still has a watermark, that can be verified using tech. What you are saying is, if a printout is taken, can I physically see the watermark in the printout?
No.
Not possible. So in that case, what is the significance of this 63 certificate?
So the 63 certificate is filed by the entity that's relying upon that document to say that I'm taking it out in the manner that I got it. Okay, it's printed from my system. But now to prove it in evidence, and that's my point, right? Now, just because it has watermarking, because watermark I can put on anything, right? The existence of a watermark is not saying that the image is bona fide. Okay, the existence of a watermark essentially says that that a watermark has been placed, and now if anything happens to this image, I should be able to detect whether the same image has been used anywhere else. I can create a synthetically generated image, right, and then put a watermark on it. That doesn't make the image genuine. It's still a synthetically generated image with my watermark on it, right? So the starting point, of course, becomes critical. Now, if you're a platform and you have embedded technology where, say, for example, I mean, your Facebooks and a lot of these platforms allow you to create synthetically generated images, right? WhatsApp, etc. Now, if you embed this technology, what it can do is that if you create an image of Facebook, okay, this watermark can be embedded in that image at the inception. Okay, so any image that is created on Facebook using any AI tool that Facebook has deployed on its website, and it has partnered with, say, Rohan, then Rohan's watermark can be embedded in that image at inception. Okay, now if you use that image, print it, or use it, that watermark is there, and Facebook can take a defense that this watermark was embedded at the time of inception. So it's not as if this image was generated and then two other people used it and the third person put a watermark on it, and therefore from that you have to look at that image from the time the watermark was put on it. It was still synthetically generated till layers before that, right?
Yeah. Rohan sir, there's a last question to you. I, being a forensics expert, we used to rely on EXIF data in images. You might be familiar with it. .exif file, which is actually the meta of the information that is there. Now, in the case of AI, Today there are tools, probably use of AI itself, intelligently remove the watermarking content. So in that case, as a solution provider, what safeguards do you provide to a person who has come and commercially bought your solution? And is it possible to remove watermark without leaving a trail or without damaging the image? I'm talking exclusively from image
That's a
point
great
of
Right.
question, and even I'm very interested in the answer.
Right.
yeah, I got different hats, no, so I can ask this
Right.
question. We used to rely a lot on EXIF data in forensics.
So the EXIF data and all of that. So essentially, what the watermark has done is basically established a link. Like in C2PA terms, it's called as a soft binding, right? Where you take all of this metadata, which was earlier looked at in the file itself. It was part of the file, and you would analyze that. But now that has become very easy to manipulate, right? So what you do is you take that metadata and you move it to the cloud in a and you store it in an interoperable way that multiple companies and tools and products understand, which is what C2PA does, right? It's defined a standard. Okay, please store this information in this way. Now the watermark is essentially a link between the asset, which is the image, and its provenance history, which is on the cloud, right?
Correct.
So there is provenance locally on the file itself also has a. So for example, let's say you go in and you change the metadata of that file, right? Now I detect my watermark. I always check the two files. I check the provenance in the cloud. What does the cloud metadata say, and what does the file metadata say? If there is a mismatch between the two, we flag it as a tampering, that somebody has tampered the actual assets metadata, because the ground truth is there with me on the cloud, right? Now the other question of tampering the watermark itself, right? Now, like I said, it leaves traces, right? If you tamper the watermark, it leaves traces to the point where we are able to say that yes, somebody has removed that watermark, right? We had it and somebody has removed it. Because see, when we watermark, we have the original. So we have
Correct.
original, we have our watermark, and then you have tried to tamper. So you have a third version, right? So we are able to establish, because every time I watermark that same image, I will always get the same watermarked image on this side, right? So that's how we are able to establish that the third image is actually a tampered version of the second one. Right, but I can do it. I mean, this needs to be interoperable, which is where there's an open question right now, which is being worked out again within the C2PA, that how do all these watermarks work with each other? For example, like we have our own watermark, Google has its own watermark, Adobe has its own watermark, blah, blah, right? So that also is being worked out. In fact, I'm part of that task force. We're trying to figure out how to make this uh, interoperable, and there's been good progress on that front, right? And I think you'll hear some news on that very soon also, right? In terms of how these different vendors are able to properly understand your mark, or at least convey that, okay, I know your watermark is there in this image.
Yeah, I thought you mentioned ISRO. What is their role?
No, not ISRO. I don't know if I. No. Yeah.
What is that organization which is now standardizing and making it interoperable for the
That's
for the
C2PA.
yeah, C2P.
C2PA. Yeah, it's the Coalition for Content Provenance and Authenticity. And it has some of the leading global companies as its members. Like pretty much every tech company, every big company you can think of. I think the only exceptions, right, as of now, are Twitter and I feel Apple, surprisingly. And otherwise, pretty much you have the likes of Amazon, Microsoft, Google, Adobe. On the hardware side, you have Canon, Nikon, Leica,
Okay.
Samsung, Qualcomm, everyone, right? So pretty
So
much everyone is part of this.
so from a legal standpoint, just to facilitate Dhruv, we rely a lot on hash value when we produce digital evidences as court. So you mean to say that when I tamper an image or try to manipulate the watermark, is the hash also altered?
Yes, I mean, I may not be the best person to answer this technically, but my sense is yes. It
I
will
think
it will
I'll ask Rohan
it
also
will
to
always be
substantiate your
tampered.
answer.
And
It
I
it
and
it
I
will be.
Yeah.
yeah.
Dhruv, go ahead, please. Yeah.
And I just want to add to what Rohan was saying, right, in terms of C2PA, because if there are people listening to this, I want them to also understand what it actually means when you add provenance on data and the importance, right? Because we've lived in a world where the internet has been about content creation. So there is all kinds of content, right, wrong, correct, valid, genuine, synthetic, everything. Because the focus has been fill the internet up with content. Now we are transitioning into a world where the focus is, I want to know what is accurate, genuine, bona fide, legitimate content, right? Like I want to know what that content is.
Correct.
So therefore, movements, I would rather call it, like C2PA, products like Rohan is building are very, very relevant. Because imagine this, from the time, think of a source of an image. It's a camera, right? Now imagine at a camera level, there is metadata getting embedded in a digital asset or an image, which is saying that this photograph has been clicked by a Nikon camera, or an Apple phone. Well, Apple is not on it, but a Samsung phone, which is clicked on so and so date, so and so time, so and so version, operating system model, etc. Now you take that image, put it up on Photoshop, which is Adobe, make a few tampering edits to that image, and now that provenance is getting added. So now when you open that image and upload it, say on LinkedIn, there'll be a CR logo on top where you will drag your mouse and that CR logo will open a box. And in that box, it will say that this image was clicked using that Nikon camera. Then it was put up on Adobe, what all edits were made, what license of Adobe was used to make those Photoshop edits, and then it came on LinkedIn, right? So you'll be able to track the journey of that image, which is, I mean, in a lot of ways, if you think about what it's capable of doing, of course, it's got its own challenges, right? The minute you take that image on a platform that is not partnered with C2P or is not part of their ecosystem, then that journey breaks. So you will not be able to get accurate provenance. But if there is alignment on how we are, if there's alignment on adding provenance to digital content, this in itself is a great movement, for lack of a better word, for me. Okay, I think
we lost.
Koshy sir is not here. I don't know, sir, if you're here.
I think
If you're
we
not,
lost.
I'll take over the discussion and and ask if there are any questions, because I know we are also at the fag end of this session. Any questions from the audience? I just see
Hopefully,
comments.
we just experienced some internet issue,
No
but
problem.
No problem.
I just
we don't have questions, although we have comments that it has been a very interesting discussion. I think we have received that it is very insightful discussion. I think this is a place where people are still, looking into how exactly they can navigate through this. So I'm sure this session and this webinar was very helpful, and we do have Koshy join in. Just a minute. Yeah.
Yeah. Real, do we have any questions, please?
So your image is looking synthetically generated.
So we don't have the question, but I was just telling the panel that we have received feedback that thanks for sharing this information, and it was a very interesting discussion.
And thank you, sir. I think there is something wrong with your internet connection, but
Yeah, Priyal, I think you can submit, please.
no. There is a question over there.
I think there's one question.
Yeah, I'll just showcase it. I hope you're able to see the question.
Yeah. Maybe, I mean, I can share my 2 cents and I can leave it for Rohan and Utkarsh also to answer it. Effectively saying that, look, the law requires intermediaries to use technical measures to say identify SGIs, right? And if we are using platforms like C2PA, then to comply with the SGI obligations, then how do intermediaries manage liability if these markers can be stripped or bypassed? Are we effectively mandating deployment without guaranteeing reliability? So actually, just maybe Utkarsh, like from a C2PA perspective, is C2PA in that sense foolproof if platforms try and adopt it? If it can be stripped, is it like a good standard to even adopt?
Yeah, I think that it will bring us to the same comment that I made earlier, that C2P also allows human generated claims. Human claims that any forensic units or anyone can make on top of the provenance journey, which is machine generated provenance journey. So such claims can ensure that at least someone in the chain is ensuring that the reliability of data is maintained. And even if it's there are ways that you can retrieve back the information, as Rohan has mentioned, by storing it in cloud or blockchain. And on top of it, if you enable this human claims or digital identity system, it can be, as Colonel Koshy has mentioned, it can be done with our existing infrastructure. We already have DigiLocker and digital identity systems. We are actually working as a company. We are working very closely onto this part, digital identity and human related thing. So we are ensuring that we supports the watermarking technologies. So all in all these technologies can ensure that we have the infrastructure and technology ready for such mandates to be passed. We as in content lens and us together.
Got it. Rohan, just from your perspective, because if you think about it, C2PA will effectively add provenance to data, right? Like it adds metadata in for us to be able to essentially add provenance to it. But it doesn't really help in detection of deepfakes per se. So in terms of a technology that I'm adopting as a platform to be able to detect if there is any synthetically generated information, C2PA may not help there, but C2PA may help to add provenance on my content so that if this content is then used to create deepfakes, I am in a position to flag it using technology which can show that this had C2PA provenance and is therefore not the original image because the original image was something else.
Okay. So, see, in terms of detecting deepfake, C2PA essentially allows you to verify the content that you're looking at, right? Now, if something is stripped or if any sort of alteration has been made, you may be, just by looking at the C2PA, you may be able to tell that some tampering has been done here, so it's not reliable, right? Those mechanisms are also in place to be able to say which provenance metadata is reliable and which is not reliable, right? So no, you can't stop anyone from tampering, but those mechanisms are there. They are in place to be able to flag that this particular provenance metadata is tampered. Now, coming to whether it can detect deepfakes or not, see, essentially, the original can say, let's say the original says, this is an image of Dhruv in, let's say, Delhi. Now, the deepfake is of you in some other place. Now, because the provenance metadata actually says at source it was tagged that this photo was taken when you were in Delhi, somebody can actually say, hey, no, there's been a modification done here. So C2PA can help with that as well. It cannot be the only way, right? It is there is no one technology, I would still say, that which can be the only way to detect deepfakes. I think you need a combination of like protective technologies like marking, C2PA, and you will need the other type, the AI based detection technologies also, to flag that okay, this particular image has been modified using AI, right? So you'll need a like a 360 sort of a degree analysis of it. It can't just be any one approach which will be able to give you the right answer.
Great. Thank you for that. I think we are pretty much out of time. So if there are any follow-up questions, please feel free to connect with us on LinkedIn and We'll be happy to address any questions that come up. Priya, I don't know whether you're here, but I'm happy to close this if you're not around.
I am here
Okay.
and I will take a moment to thank everyone. There's one more question, although in the chat, so I think we can use our LinkedIn only to respond to that. Thank you so much, everyone, for such an insightful webinar. And definitely, all the attendees, if you have more questions, our panelists here would be more than happy to answer. And stay tuned for more webinars. We will be coming back shortly with more insightful topics. Thank you, Rohan. Thank you, Utkarsh, and thank you, Dhruv. And
Thank
definitely
you.
a big thank you to Binoj, sir, for leading the conversation today with us.
Thank you very much.
Thank you,
Thank you,
everyone.
everyone.
Wonderful to be on the panel. Have a good day. Bye.
Bye.